As for our third panel, you'll be happy to note that Professor Yu did get his photo shoot. It turns out, however, that Vice President Cheney did not recognize him. But we will still have that for posterity. This panel is going to be first I had to make an announcement, excuse me. Two of our panelists, Professor Yu and Professor Levenson, will be selling their new books. During the lunch hour, there will be tables set up, and you can get them. You can purchase them there and sign them. So that will be happening at lunch. This panel is moderated by Judge Thomas Griffith. He needs no introduction, least of all because you have his bio in full in your packet. But in brief, Judge Griffith was appointed to the United States Court of Appeals for the District of Columbia Circuit by George W. Bush in 2005. He has a BA from Brigham Young University, and his JD is from the University of Virginia School of Law. But most notably, he and his wife are the proud parents of 6 children and the grandparents of 4. We're also particularly thankful to have Judge Griffith out here since he was at Stanford only 2 weeks ago for the J. Reuben Clark Conference. And so at least, I don't know if it was us or the weather, but we're just glad that something could entice him to come back a second time. Thank you, Judge Griffith.
Great. Thank you very much. It's a pleasure to be here, and my congratulations again to the conference organizers, and thanks to Michael, Ilan, and Barbara. Although, Ilan, I wish you hadn't just remarked that I was out here 2 weeks ago in light of Mr. Gray's comment last panel that the D.C. Circuit is woefully underworked. So, good morning. For those of us who are familiar with gatherings of the Federalist Society, this is the obligatory panel on the part of the Constitution that seems to be of the greatest interest to Federalist Society event organizers everywhere, at least when a conservative administration is in power. Those 3 enigmatic and inviting words in the Constitution, quote, the executive power, close quote. As the moderator of this distinguished panel, I plan on being seen more than heard, but I do feel obliged to answer a question I know that my colleague and friend Judge Silberman would want me to answer before going further. What are you doing on a panel about the executive power? You see, my colleagues on the D.C. Circuit, for whom I have boundless admiration, make 2 assumptions about me, neither of which is correct. First, that my time as Senate legal counsel predisposes me to side with the Congress in disputes between the political branches. And second, that my association with BYU and its sponsoring church means I must know Mitt Romney. About that first assumption, the fact that I once had a statutory obligation to defend the powers of the Senate when they were called into question, and to advise the Senate leadership how best to use those powers does not mean that I don't have an appreciation for the importance of the executive power in the constitutional scheme. Now, you may think that the impeachment trial of the President of the United States is an odd place to display such appreciation, but as those of us who were involved in the Clinton impeachment will recall, the Senate leadership was committed to showing more respect to the office of the President than Mr. Clinton had. And so for Judge Silberman and like-minded skeptics, I assure you that I have no bias here. Although I do note that the powers of Congress come first in the Constitution, but we can talk about that later. As you've seen from your materials, we have assembled a distinguished panel today. Departing from the pattern used by Judge Bea last evening, I will provide brief introductions to all the panelists at once and then turn the time over to them. In the order in which they'll be speaking today, we first have Professor Sanford Levinson of the University of Texas Law School. He has written literally hundreds of articles and book reviews. And if I can add something personal here, his scholarship on the Second Amendment was of special interest to this member of the panel that first considered the case that was to become Heller. But we're not here to talk about that. Professor Levinson is the author of 5 books, including one, Framed, America's 51 Constitutions and the Crisis of Governance, which is coming out this month, which was referred to before. Among his most recent publications on the executive power is a 2010 article in the Minnesota Law Review with Professor Jack Balk entitled Constitutional Dictatorship, Its Dangers and Its Designs, an issue which he may address further today. Next will be my friend Professor John Yu of Berkeley's Law School. I first met Professor Yu when we worked together as Senate staffers. Of course, Professor Yu's name is virtually synonymous with the robust and muscular understanding of the executive power. He's published widely on foreign affairs, national security and constitutional law, and has served in all three branches of government. He was Deputy Assistant Attorney General in the Office of Legal Counsel, General Counsel to the Senate Judiciary Committee, and a law clerk for Judge Silberman before clerking for Justice Thomas. Professor Tino Cuellar is Stanford local. We're glad to have the strong representation from Stanford faculty at this conference and appreciate him being here. His research and teaching focus is on administrative law, executive power, and how organizations implement regulatory responsibilities involving public health and safety, migration, and international security in a changing world. In 2010, President Obama appointed Professor Cuellar to the Council of the Administrative Conference of the United States. Last, but certainly not least, Professor John C. Harrison, who is the James Madison Distinguished Professor of Law at the University of Virginia. Wahoo wah. That's a Virginia thing. I guess the Cavaliers are not well represented here today. So, Professor Harrison's teaching subjects include constitutional history and federal courts. Professor Harrison also served as Deputy Assistant Attorney General in the Office of Legal Counsel and clerked for Judge Robert Bork on the D.C. Circuit. Professor Harrison was on leave from the law school to serve as counselor on international law in the Office of the Legal Advisor at the U.S. Department of State in 2008. Now, today's panel is titled Czars, Libya, and Recent Developments, Perspectives on Executive Power. But we, after discussing the matter among ourselves, we took the prerogative to settle on a slightly narrower theme of the relationship between constitutional design and executive power. And we've broken down this issue into three questions. First, how does our Constitution distribute power that is executive in nature among Congress, the President, and the bureaucracy? Second, what are the benefits and problems of such a constitutional design? And third, what might an ideal constitutional design look like? To give each panelist sufficient time, I will vigorously monitor the time limits. We're going to ask each panelist to speak for 10 minutes. Rather than passing notes as they approach that time, I will simply announce when 1 minute is left. And because I favor the manner of Chief Justice Roberts over his predecessor, I will not cut you off mid-syllable, but will allow you to finish the sentence. With that in mind, I turn the floor over to Professor Levinson to begin the discussion.
Thank you. I too want to thank very much the organizers for inviting me here. I think the two panels so far have really been outstanding. I've learned a lot. With regard to the title of the original panel, because I can go over that very quickly, and one of the reasons I think that this might not break down on usually predictable liberal-conservative lines, with regard to czars, I tend to share the views of my very good friend Bruce Ackerman that it is a very unfortunate development to have more and more czars appointed. I do think that the reason for more and more czars is the failure of comity by the Senate actually to give timely hearings and vote people up and down, and perhaps we can talk about that or not. Mike McConnell adverted to that in the last panel, but I don't think the rise of czars is anything to be proud about. I disagree with the robust reading of the war power offered by former Yale Dean Harold Koh, and I therefore disagree with a number of things that John has written. We could also talk about recent developments, recess appointments, things like that. But I do want to go to what we agreed on more was something to talk about, in part because it is my central interest these days, and I want to try to tie this to both of the panels that we've had, the one last night on, among other things, line item vetoes, and the one this morning, because one of the things that I found fascinating with regard particularly to the second panel was the degree of radicalism shown by my good friend Mike McConnell, who I think is probably not usually described as a radical. But I think that Judge Professor Michael did touch on some absolutely crucial issues that are central to our particular topic. The degree of his radicalism perhaps can be exemplified by the extent to which not only he, but a number of the discussions replicated the great debate in the 1960s in China over the issue of red versus expert. That is to what degree the state, particularly if it is a modern state, and last night I do think even Richard Epstein, wave the flag of surrender with regard to the existence of a very significant administrative state that will engage in a wide degree of rulemaking. And then, as several of the speakers have articulated very carefully, the debate is, well, how should the rules be made, and what is the relative trade-off between looking to land this kind of experts or to looking either at the demos, this is kind of the democratic critique of expert administration, or to adapt a little bit to the Chinese analogy. It's not the demos at large, but a particular portion of the demos with the correct political values. And where politics is seen by and large as the choice of values rather than the articulation of rational means-ends relationships to how you get there, where expert knowledge can be relevant. But there's one other way in which I appreciated Michael's radicalism and think that actually doesn't go far enough, because Michael called for two things. The first was basic reform of congressional organization, which I strongly agree with. He has talked about the filibuster rules and other aspects of congressional organization. And he also suggested, and several other speakers suggested, that it's time to return to the Administrative Procedure Act and to ask if if an act basically drafted in the mid-40s still serves us well 60 years later. I'm not a professor of administrative law. I have no informed opinions on the adequacy of the Administrative Procedures Act, but what I thoroughly applaud is Michael's injunction that we actually look with a critical eye at whether the Administrative Procedure Act really is fit for our present government. And what has become my hobby horse in recent years is that I think we should have the same spirit of critical scrutiny toward the Constitution of the United States. We could have an argument, though frankly I think it would not be very productive. I think at this point, with regard to the debates about, say, John's view of executive power and the views of his critics, it's a little bit like the comedians' convention in which we can just shout out a number and, you laugh or not, but everybody knows what the arguments are. I'm willing to stipulate, something I in fact don't really believe, but I'm willing to stipulate, for sake of argument, that John gets it exactly right in his reading of what the 1787 Constitution means. That, in fact, it was designed to create a president with the powers of Hanoverian kings. Now, what I would ask us to think about is, even if, again, by stipulation, perhaps there was reason to do that in 1787, does it make much sense today if we were designing a constitution anew? One thing about Hanoverian kings is they tend to be dolts. There was no reason for the American Revolution, frankly, other than that George III was one of the most inept kings of all time with regard to responding to the grievances of the colonists. And if he had been more politically astute, if he accepted Edmund Burke's advice, for example, there's every reason to think that we would have ended up like Canada, rather than a very bloody and destructive war that got us our independence. And I'm not saying that I'm not glad we're independent, but if one is making analogies, then certainly it doesn't. there are a lot of things wrong with monarchies, and one of the things is that monarchs aren't selected for their sagacity. So one of the questions that I have that I think we ought to spend much more time talking about is whatever you think the executive power means. And as I say, for purposes of this panel, I'm willing to defer to John, whether I agree with him or not. Is the modern president likely to be somebody to whom we defer as much as we do across the spectrum of, say, commander-in-chief, chief economist, chief public health officer of the country, chief disaster specialist? And frankly, it seems to me that in the 21st century, the answer is no. That presidents of the United States are perhaps fairly extreme examples of not reds, but of amateurs versus experts. With regard to, say, the commander-in-chief power, I think the last president in whom I have genuine confidence to be commander-in-chief was Dwight Eisenhower. And that's no coincidence. He actually was the de facto commander-in-chief of the greatest military victory in history. And a very important book that I read last year called Eisenhower 1956, frankly, in spite of my own politics, I ended that book relieved that Ike beat Stevenson for the presidency because Ike was able to stand up to the military, because he knew something about the military. Since then, we've had a string of amateur presidents, some of whom you might like, some of whom you don't. I'm not a fan of George W. Bush, and therefore I was horrified by some of the things that John wrote about presidential power. I assume that many of you in this room were no fans of Bill Clinton or Barack Obama in terms of their capacity to be commander-in-chief, and I think all of us are right, that you wouldn't select out these people to make the decisions of peace and war, life and death. Shift to the financial crisis. One of the most interesting books on that was written by a reporter of the Wall Street Journal whose name I'm freezing on right now. And one of the points he made is that the decisions, again, whether you like them or not, the decisions were made by the head of the Fed, that is Ben Bernanke, and the Secretary of Treasury, Hank Paulson, who one can stipulate know something about the economy. George W. Bush basically is next to nowhere to be seen in this book, and nobody in the reviews has suggested that he got it wrong. And frankly, I'm more reassured by Bernanke or other heads of the Fed who might like more than Bernanke than, let's say, either Bush or Obama, whom I supported with great pleasure. And I do think that there are so many issues of constitutional design. I'll mention just one last before the gavel comes down. One of the things I found bizarre about last night's very, very interesting panel is the assumption that in talking about the line item veto, there's only one Constitution in the United States. Now, again, I'm willing to stipulate that the Supreme Court got it absolutely right as a reading of positive constitutional law that the U.S. Constitution doesn't allow the line item veto. What I think is just bizarre is that we don't even talk about the fact that most states have the line item veto. Most states reject the unitary executive. The unitary executive is an aberration of one of the 51 constitutions of the United States. And I think that especially elite law schools, the higher you go up in the pecking order, the less likely the students or the professors are to know that there exist state constitutions, except perhaps in California, where it's impossible not to know the importance of the state constitution. I think it's extraordinarily important to integrate the little laboratories of experimentation and to see how different a lot of the states are, including, I suspect, in structuring administrative law, and whether there might be something to learn from that rather than to repeat what are basically now rote arguments about how best to interpret I think, the inevitably vague and ambiguous terms of the United States Constitution.
Thank you, Professor Levinson. Professor Yu.
I'd also like to thank the Federal Society for having given me the chance to leave the city of Berkeley and come to a more conservative place like Stanford University. And I'm glad Ilan and the organizers were able to arrange. I don't think they're real protesters outside, including Darth Vader, because A, they know me too well, because they know I love the Imperial side in all the Star Wars movies. I always think it's unfair when the Jedi Knights just come along and try to fix everything. It's like they're like federal judges in judicial review. They don't actually fit into the constitutional system. They got robes. They have little clerks following them around, doing their bidding. And they intervene in all levels of government without any writ, right? I mean, it's very interesting. I recommend someone's going to write a student note about this now, I'm sure. But the other reason is because if you're getting protested by Darth Vader, that means you're the good guys, right? So I guess next time I guess I'm going to get protested by someone in a Curious George outfit who's going to accuse me of working in league with the man in the yellow hat. The last thing I'd like to say is it's a really good pleasure to be here, not just with my friends on the panel, but with I'm really glad to be on a panel that does not have, one of the few panels today that does not have Richard Epstein on it. So I am finally going to get a word at edgewise with Richard because he's just not allowed to speak until the question and answer period. Well, he will rectify the imbalance, I'm sure. Where is Richard?
Here he comes. No questions yet, Professor. No questions yet.
I just have one personal story. Richard and I have this podcast we do every 2 weeks, and after one, we happened to be in New York, and I thought it would be fun to go to a Jewish deli with Richard in New York, where he's from. And so we went to the, I still mispronounce it, the Carnegie Deli, where Richard proceeded to instruct the waitress on what all the sandwiches should have in them. So that was really a lot of fun. So I actually very much enjoyed Sandy's remarks, and I sympathize quite a bit with him, and I agree that the scholarship in our field is moving in this direction, more about constitutional design rather than sort of historical legitimacy or historical authenticity. And I just wanted to take what he had to say a little bit farther, in that I'm not so convinced necessarily that even if we were going to design a modern presidency today, knowing what we know now, that we would design one that's that different than what the original presidency was supposed to be. I think a lot of the problems we have, perhaps with the performance of the presidency today has to do with a lot of duties and purposes that we assume the presidency have, which were not necessarily what the framers in 1789 wanted. And so we're having a difficulty of reconciling who we elect as president, and sure, we can all say they have various deficiencies, and the kinds of tasks and duties that we expect of them, which I think actually go well beyond the constitutional design. The other thing I just mentioned when I was listening to Sandy talk, I thought it was really fascinating, and because of his talk, I'm going to go out and buy his book at lunchtime, but that doesn't mean you shouldn't buy mine too. But I'm going to go by his. It's that it actually got me thinking whether the presidents that he's talking about, whether the good and bad presidents, which I've been very interested in, would correlate with the kind of qualities he wanted. So it would seem to me that Abraham Lincoln would be a president we would not have wanted to elect to office. Right? Talk about someone who was a loser. Right? He had only won one term to the House. He became famous by losing a Senate race, and he was everybody's second choice. You couldn't have predicted beforehand that he would be good at the presidency. He certainly didn't have any expertise that would have led you to think, right, you might have wanted to elect George McClellan as president, right, during the Civil War, and he did run in 1864, and he lost. And then on the flip side, I was thinking, what president in our time might have been most who might thought on paper was most prepared for the domestic side of the presidency, surrounded him with the smartest people, himself with the smartest people. And the person I came up with was Richard Nixon. Right? Nixon was many people think he was a great foreign policy president, and think who he had working for him in domestic policy, George Shultz, Moynihan, people like this. And he had some very innovative ideas, but doesn't necessarily mean that his presidency turned out so well. And so that brings me to the point I was going to make in broader scope, was that I think part of the reason we have this problem is because I think the framers' design for the presidency is quite different than the one we expect. I think today we tend to focus on the American presidency for its, primarily, or at least at equal parts for its domestic program, where I think the framers actually had a much narrower view for the presidency in mind. where I think the framers really expected the executive branch to be primarily devoted to foreign affairs. And here I actually think we have seen in the last 10 years presidents actually, despite George W. Bush's presidency, trying to actually almost bind themselves in foreign policy. So in domestic affairs, if you read the Federalist Papers, there's not a lot of discussion about the role of the president in domestic affairs. I think you would be surprised, the framers would be surprised to see the kind of president we have today in this area. Let's read some Federalist number 7. They thought the president would be a check on Congress, not someone who would be constantly urging and pushing Congress to enact the president's program. So in Federalist number 70, Alexander Hamilton says that the president, a vigorous executive is necessary to protect against the irregular and high-handed combinations which sometimes interrupt the ordinary course of justice, provide security against enterprises and assaults of ambition, of faction, and of anarchy, which emanate, I love this phrase, from quote-unquote, the humors of the legislature. Tom and I worked in the legislature. There's not a lot of humors there, but I guess that's why they rectified that and elected Alan Franken to the Senate. And when you look at the discussion of the veto power by the Federalist Papers and first, it's not talked about as this sword to be used by the president to convince a Congress to enact his or her program. It's discussed as a way for the presidency to protect its own constitutional authorities and to, what quote calls, furnish an additional security against the enaction of improper laws, against laws that would be unfriendly to the public good. So in one respect, I think the reason why we have this disjunction is because we have presidents who feel now today that it is their role to promote an active domestic policy, to actually, in some ways, integrate themselves with the activities of the legislature. And this is something that not only runs against the framers' design, I think explains at some level why President Obama has been having the problems he's been having in public opinion polls, because I think he got too close to the legislature in the passage of Obamacare or the TARP and the stimulus. And in fact, he gets blamed for all of them, even though much of those laws were written in Congress. Right? But if you talk about all the various shenanigans to get Obamacare passed, I love all the names like Gatorade for Florida, the Cornhusker deal for Nebraska. Is that Nebraska? They're the Cornhuskers, I think. All those deals, right, we all attribute them to Obama, right? But they're not his doing. But because I think the president became too close to Congress, too associated with the activity of passing legislation rather than trying to check Congress, the president's opinion polls and his approval by the people sort of start to track the very low opinion we have of members of Congress. At the flip side, I think in foreign affairs, this is where I think the framers did expect the executive branch to come to the fore. It's the only reason, if you think about why you need to have an independent executive that's separate from the legislature. We could have a parliamentary system of government where the majority party in the legislature appoints the cabinet members who are going to execute their policies. But in foreign policy, the framers thought one ought to have something different because foreign policy has unique differences from domestic policy. Foreign policy is unpredictable. It's very difficult for the legislature to pass laws in anticipation of what's going to happen in foreign affairs. There's more advantage to having one person act with what the framers called decision secrecy and dispatch, because the national danger, the harm to the country might be greater, and so we might be willing to accept more errors by a single person in exchange for being able to act faster and more quickly. And that's why Alexander Hamilton, the Federalist number 74, says, war is the greatest challenge. War is that area of human life which is best suited to control by the executive, administration by the executive. Right? So I think the basic trade-off between, and I think this responds more directly to Sandy's point, is that you could have a government by legislature, which we see in a lot of European countries, right? Parliamentary systems of government. But they trade off. It's very hard for legislatures to act quickly. They may make less mistakes, right? The more people who participate in a decision, the less likely they're going to make an error. But in foreign affairs, I think, but our Constitution, I think, creates more checks and tries to make it harder for domestic policy to get passed, in part because there's no great harm from slowness in domestic affairs. There's always the states that can regulate things. If the national government doesn't do something, it's not like there's a vacuum or absence of federal action. In foreign affairs, however, there is that kind of cost from inaction. There is advantage for acting faster. So with my 1 minute left, I'll just bring it back to the actual topic of the panel, which is Czars and Libya. So to me, I actually agree with Sandy. I don't think Czars are constitutionally problematic. I think as a matter of administration, they might be a bad idea as policy, but I think it's because presidents have taken it on themselves to try to get so involved with the legislature, so involved with the laws that they need more and more people to assist them. But I don't think it raises any great constitutional difficulty. Libya, however, I think is a demonstration in the last few years of how presidents actually have been trying to bind themselves to reduce the kind of vigorous constitutional presidency that should operate in national security and foreign affairs. For example, what struck me about Libya was the claim that Libya was not a war, which I think would have surprised Mr. Gaddafi since we were trying to kill him during the conflict. But also that we delayed our intervention for 2 to 3 weeks so that we could get United Nations approval, where the current administration thought it was more important to get approval from the United Nations than from Congress. And I thought was the remarkable thing, that the presidency trying to actually limit its own freedom of action by tying the fate of our national policy here to an organization that's not even part of our political system. Thanks very much.
Thank you, Professor Yu. Professor Cuellar.
Thank you very much. I'm very honored to be here, and I wanted to first and foremost thank the organizers of the conference for this invitation. I salute Barbara, Michael, Ilan, Gabe, and your colleagues for organizing this conference. I've had the pleasure of having many of you in class, and I'm delighted to see you here. I also want to congratulate all of you for being in the audience, because there are many other ways you could have spent your Saturday morning. For those of us who are passionate about this topic, we couldn't imagine doing anything different on a Saturday morning. In fact, my kids, who are 7 and 5, spend most of their Saturday mornings sort of thinking about these very things. That has turned into a dangerous thing, and I'll give you one specific example. My 7-year-old daughter said to me the other day when I asked her to take out the trash, said, "Papi, I think there's a problem with one of your doctrines. You didn't say what kind of trash, you didn't say where I should take it, you didn't say how much I should take it, or how long I should take before coming back." So I might have to change my strategy there. I want to take just a few minutes, I hope not to take all my time, to make basically just 2 points. One point is to situate some of this discussion in a little bit of historical context, and then the other is to observe a little bit how history is evolving. And I hope in the process, not so much to directly answer some of the questions that we should all address, but at least to further put some of the scaffolding on the context of how we should think about these things. I want to start with the Reagan administration because it's hard to find a better place in the last 50 years to think about a great deal of national level discussion about the role of the presidency in foreign affairs and in domestic affairs. And I'd submit to you that the Reagan administration stood for the proposition that a vigorous executive could play an important role in the country in both domestic affairs and international affairs. I would note that on the domestic side in particular, just to emphasize that, given John's very interesting comments, many of the leading cases that we talk about in administrative law today, that you've probably discussed if you've taken administrative law, are about the Reagan administration. State Farm, EDF v. Thomas, Coastal. These are cases where the White House is trying to reflect a particular philosophy, a particular approach to how the law should be implemented, and an approach that not everybody in the country agrees with, but that, as Justice Rehnquist says in his concurrence in part in State Farm, reflects a degree of democratic legitimacy, an interest that the administration has in implementing the laws, and as much as they're consistent with the law, with the statutes, in a different way. How, Justice Rehnquist asks, can we not expect elections to matter when the administrative state does its work? If we still expect legitimacy to flow from the president, and that notion of legitimacy is not just something that goes back to the Reagan administration. It goes forward into cases like the free enterprise case, which was alluded to yesterday, but it also goes backward in time. And that's what I want to draw your attention to. What I want to do is I just want to read a very little bit from some documents circa the Roosevelt administration. And then I'm just going to briefly quote some testimony from the Truman administration that will show you that what was afoot in the Reagan administration was in some respects not that new at all. To put this in context, I want to just note that all of us here have probably heard about the battles that the Roosevelt administration had with Congress vis-a-vis court packing. What you may not have followed so closely is that a parallel battle, just as intense in pitch at the time, probably comparable to debates today about the Affordable Care Act, reflected the Roosevelt administration's interest in reorganizing the executive branch. Roosevelt was clawing for authority to reorganize the executive branch. When Congress slapped that down, just as it did the court packing plan, interestingly enough, the Roosevelt administration did not take another run at court packing, but it did take another run at executive reorganization. And if you want to hear more about exactly what happened, you can read a book that I've written that is about to be published but is not on sale today. But I want to instead draw your attention to a very interesting set of documents that I found buried under stacks and stacks of papers in the Roosevelt Library, describing what Roosevelt's staff was saying to the president about the importance of reorganization. I'm just going to literally let the documents speak for themselves. And I quote here, "As a guide to the timing of steps in reorganization, the following is suggested. First, do those things which, when done, will reduce the difficulties of the president in dealing with his multifarious duties, and which will assist him in discharging his responsibilities as the chief administrator of the government. Second, do those things which, when done, will advantage the work of those administrators who have been chosen by the president to assist him in the discharge of his duties, whose responsibility to the people is through the president. Third, do those things which, when done, will advantage heads of departments in the discharge of their own responsibilities." The memo goes on a little bit, and then it has a note at the bottom that says historical note. And this is what I found interesting. Roosevelt's aides are describing to the president the result of an effort that was undertaken by a commission to see how the federal government should be reorganized. And this is what the staff tells Roosevelt. "It is an interesting fact that few federal administrators have spoken to the members of the President's Committee on Administrative Management in terms of the interest of the President or the Presidency or the administration, but nearly always in terms of the immediate and particular interest of a department or a bureau, as if it were a satrapy." A couple of things to observe about this. Number one is the extent to which Roosevelt's staff understands the president to be the chief administrative officer of the government. We can argue about whether that's right or wrong. My point is that when the Reagan administration approached this problem, it was not doing so on a blank slate. Second, it's interesting that the staff are concerned about how even hand-picked, very loyal political lieutenants in agencies might actually have a divergent view vis-a-vis the president. Fast forward just a little bit to the Truman administration, and here's one of Truman's agency officials testifying before Congress describing how he views his role as a presidential appointee. "The department head must be regarded as an extension of the president's personality. He's expected to carry out any basic instructions which a president may provide for his guidance. Political attitude, which this appointee describes as an important role for the appointee to bear in mind, reflects prevailing beliefs on broad public issues, beliefs about the scope and magnitude of government activities, about both the ends and means of government action." My point here is that the Truman administration reflects agency officials describing to Congress their understanding of the role of agency heads as folks who have not only an expert technical role, but also a role of engaging in political judgment with a little p. This is what I want to observe just in closing up. Clearly, you're talking here about a long-running effort on the part of presidents from both parties to figure out how to make sense of their responsibilities vis-a-vis a very large government. A large government that, I might add, notwithstanding some instances of presidential efforts to get legislation enacted, has largely been created, almost entirely created, by Congress itself. That has culminated in an effort to enlarge the executive office of the president, to create senior aides to the president that have responsibility for dealing with cabinet officials, people like Harry Hopkins in the Roosevelt administration, John Ehrlichman in the Nixon administration, Henry Kissinger in the Nixon administration, Roger Porter in the George H.W. Bush administration. But I also want to note that this discussion within the executive branch was not happening with a judicial vacuum. If you look at the Midwest oil case from 1915, Curtis Wright, Youngstown, Dames and Moore, these cases, again, are almost household names for law students. They reflect a judicial recognition of the special role of the executive in both domestic and international affairs. But I'll end by noting that the passage of time matters, and that to the extent that presidential power is changing in nature, I would argue that it's partly something that is being driven by Congress. And in part, it's being driven by a competition among different congressional committees to enlarge the jurisdictions of particular agencies and resulting in a an executive branch that often involves agencies with overlapping jurisdictions. These overlapping jurisdictions often place the president in a strange quasi-adjudicatory role, where the role of the president is in part to deconflict, to figure out how to coordinate different agencies. It's important for us to recognize that courts have a very important and central role in our system. But when it comes to the issue of supervising and constraining executive power in particular, I'd submit that courts also face great constraints. Some of those constraints are prudential, they're from the political question doctrine, they're from unreviewability, they're from standing constraints. And ultimately, where that leaves us, I think, should be in recognizing that courts have an important role, but further recognizing that the rule of law is very much in our own hands, and by that I mean in the hands of the people that are appointed to executive agencies, who always have the choice to say, this is not what I signed up for, this is not what it means to be loyal to the Constitution, I am leaving this job, and ultimately in the American people who go to the ballot box. Thank you very much.
Thank you, Professor Quar. Professor Harrison.
Thank you, Chair Griffith. My presence here is an example of what you might call just-in-time logistics. As a result of some travel difficulties that I don't want to tell you about, I arrived about 15 minutes before the panel was scheduled to start, so I am here. And in the interest of last-minute adjustments and spontaneity, I am going to substantially depart from what I was originally planning to say, which was largely about war powers and a little bit about Czars, and instead talk more broadly about the topic we've been discussing and pick up from some of the things that everybody else on the panel has already said. And the first thing I want to talk about by way of illustrating the centrality of the presidency, and as a result, the centrality of the identity of the president at any time, picks up from something Tino said a few minutes ago about the way in which the Truman administration, after the Roosevelt administration, reconsidered a number of important aspects of executive power and administrative law. One of the things that the Truman administration gave us is an almost certainly and potentially disastrously unconstitutional statute governing presidential succession. This is an issue on which both, I suppose, John, you and I would have strong feelings, because the story is that President Truman overruled the Office of Legal Counsel, and whenever the president overrules the Office of Legal Counsel, the result is disaster for the Constitution. The presidential succession statute runs the succession to the presidency from the president to the Speaker of the House, then the President pro tempore of the Senate, then through the cabinet. For a long period before the most recent changes, which were done under the Truman administration about 1945 and 1946, when the statute was reconsidered and revised in light, essentially, of modern warfare and in particular nuclear weapons, for the preceding 70 or 80 years after the change around 1880, the congressional officers had been taken out, and the line of succession went entirely through the cabinet, which was a very good idea, both for policy reasons, because it made it impossible to change the party control of the presidency by killing the president, which now can't be done again if the congressional officers are in the line of succession. And better yet, and perhaps more importantly, it is at best highly doubtful, in fact, whether it is permissible under the Constitution for the congressional officers to be in the line of succession to the presidency. They are almost certainly not officers, as they're referred to in the presidential succession provisions of the Constitution. So imagine that something very, very bad happens to the president and the vice president, and that the Speaker of the House and the Secretary of State are of opposite political parties, the Secretary of State being of the President's party, the Speaker, let's assume, being of the opposite party, and that they are bitterly divided on some major policy question. And someone advises the Secretary of State, you know, the presidential succession statute that says the Speaker of the House becomes president is actually unconstitutional. Well, I don't even like to think about what might happen under those circumstances. And it is Harry Truman's fault. And the point I want to make here is just, first, it's an important thing to know, and it's a fascinating story. But President Truman, this is something particular to him, happened to believe very strongly that it was very bad for someone who had never been elected to act as president. And so when the statute was revised right after World War II, he was adamant, even to the point of overruling OLC, something no president should ever do. He was adamant that somebody who had been elected ought to be in the line of succession. And despite the constitutional difficulties with the arrangement, and despite the problem of changing party, President Truman said, well, I'm the president, and that's what we're going to do. And one reason we have that, and so much particular power in the President of the United States, is, of course, we have a quite short, a quite spare Constitution, and one that is very, very hard to change. And put all of those things together, and you have a great deal of authority still vested in the President, even if 200 years later, as Sandy was saying, it's entirely possible that if the Constitution were seriously rethought, a number of changes would be made. But I think the single most important change that might well be made, again, to pick up what he was talking about, would be the constitutional creation of an independent central bank. But that is not feasible simply because of the difficulty of amending the Constitution. And as a consequence, the Constitution is too hard to amend. Again, think of state constitutions. They are much easier to amend, and they adapt to the times much better. We still have the original Constitution, quite short, quite brief, as John Yoo said, designed for a presidency that does not necessarily fit with the modern presidential role, and in particular, the role of the president as domestic leader. Although I will say the idea of the president as legislative leader began almost at the beginning. This is one of those topics where the plan went awry almost from the outset. And Jefferson was the leader of a political party and was immensely influential with Congress, and, like President Truman, was able to get what he wanted done. Now, having, in a sense, criticized the Constitution for being too hard to amend, for being so brief, and being so brief in particular about executive power, and hence putting all sorts of important decisions, like the one about presidential succession, specifically in the hands of the president, I will say that if you wanted to justify the system we have, and wanted to say what is the role of the president, and we're thinking about should the president be making detailed decisions about how to structure the bailout, should the president be deciding monetary policy, quite possibly no. But one powerful argument that can be made in favor of the quite brief and spare system that we have that puts so much stress on the identity of the president is that it creates a role for the president that maybe somebody can do. And one of the things I think that specialists in separation of powers and specialists in executive powers tend to underrate is the insight on which Chief Justice Taft's opinion in Myers against the United States is built. And part of the problem is that the opinion is, shall we say, I don't want to make too much fun of Chief Justice Taft. I will call it bulky and just leave it at that. But the fundamental insight of Myers is that if the president has the power to appoint and the power to remove, Chief Justice Taft, who had been president of the United States, thought those two powers together were really all the president needed. And he might have been right. Because if the president can decide in whom he has confidence, if the president can decide often in very technical areas, like, for example, monetary policy, this is the sort of person who the general political tendency that I lead and the general political tendency that caused me to be elected should have in this role. And if the president can then take somebody out when he loses confidence in that person, even if he doesn't understand what has gone wrong, if he knows that something has gone wrong, well, then all the people really need to ask when they elect the president is not, do you know anything about monetary policy? Do you know anything about emergency management? Do you know anything about nuclear disarmament? But one, what is your basic worldview? And two, are you the sort of person who can decide which expert to trust, can decide in whom all this confidence should be placed? Do you have those fairly rare skills of management and assessment of other people that make it possible to be the Taftian president? And I don't want to be Pollyanna on this. If I were starting with a clean sheet of paper, we would not come up with the Constitution that we have if I were in charge. Perhaps it's just as well that I'm not. But there is something to be said for what we have, and one thing that is to be said for what we have is by creating this central figure, by creating the presidency and giving the president a task that a single individual actually can perform, it makes it possible for the spare old system, maybe even if we would replace it, and I would, still to function. Thanks.
Thank you very much. Well, this is a good start to the discussion. What I'd like to do now is to open the discussion to members of the panel to respond to thoughts that they heard expressed by their colleagues, and we'll let it go from there. And then we will leave about a half hour for questions from the audience. Professor Levinson.
Yes, I agree with, I suspect, at least 95% of what John has just said. I want to touch on one, the Succession Office Act, I think you're absolutely right. I think one of the interesting questions is, it's been 60 years. Why is it that there is no serious discussion of this? Because there are a few of us who have actually written about this. And I think part of it is because the legal academy and the legal culture at large is rights obsessed and regards this kind of issue as dull and boring and not worth our attention. But I think for the reasons that John sets out, the Succession Office Act is very much worth our attention, and the brunt of work I'm doing these days is that the dull and boring issues that are consigned to high school civics courses, assuming any are taught any longer, are in fact at least as important, and I would argue are really more important than most of the rights disputes we get into, because rights can change, for better or worse. You win some elections, you appoint some judges, and you will get different sorts of understandings about rights. But if, for example, you think that one of the unfortunate features of our political system is the extent to which the presidential veto has turned us into a tricameral rather than a bicameral system, in part because it's not impossible to override a presidential veto, but it turns out that 95% of all vetoes are upheld. And we might have different sorts of results if it were a 55%, or even what Adrian Vermeule has spoken about, switching from a majority of those voting to simply a majority of the actual membership of the Senate. But these all strike people as boring. One of the things that frustrates me, I must say, about the Legal Academy is that we chop down forests to discuss the counter-majoritarian difficulty of judicial review and never talk about other counter-majoritarian difficulties in our system, including bicameralism and the veto. A couple of other points, because I know we should proceed quickly. The Lincoln problem. We've had 44 presidents. So much of the discussion turns out to focus as if it's an N of 1, so that proposals are often judged about, what about Abraham Lincoln? So let's talk about Abraham Lincoln for 30 seconds. He captured the White House with 39.8% of the popular vote, and it was that election that triggered a war that killed 2% of the population. Now, you may or may not believe the war was a good thing. I'm decidedly ambivalent. To the extent that I support this conflagration, it is basically because of humanitarian intervention to overcome slavery. But quite frankly, if one is anti-slavery, one ought to believe that the 1787 Constitution, described by William Lloyd Garrison as a covenant with death and an agreement with hell, should not itself have been ratified. But even independently of the war, I'd say there have been 44 presidents, and it would be good, and an N of 44 is certainly not a very high N, but at least we might discuss the overall experiences we have had. John is right that presidents are legislative leaders at least as early as Jefferson, but one thing about Jefferson is that he didn't like speaking in public. So we have what my colleague Jeff Toulis calls the rhetorical presidency that arises with Woodrow Wilson, who really makes the president much more into a cult figure. And I do think that one of the very unfortunate features of our political system is the president serving as head of state as well as head of government. And I also think that one of the differences between 1787 and today is that we expect presidents to be highly partisan leaders of their political parties, and that is taken into account with regard to vetoes and appointments. So the only area we disagree on in what I thought were really your extraordinary remarks is that I would trust more a president who fit the Madisonian or Hamiltonian notion of the virtuous person interested in the public good than a president who's always looking at next election and where confidence is based in part on the vote in Ohio. And I think that we really do need to talk about how one integrates the reality of a modern party system into an 18th century constitution that was drafted under what we in retrospect can regard as the almost lunatic assumption that there would not be a party system and that would not end up responding to politics. Let me just end by quoting James Madison and trying to get some credit for being Madisonian myself. My favorite passage in all of the Federalist Papers is the end of the 14th Federalist, where he emphasizes that we should learn the lessons of experience, and praises the revolutionaries for not being bound up by what he calls names or tradition, and instead forging new understandings for a new world. And I don't spend much, if any, of my time founder bashing. I think they did the best they could for 1787. The people I want to bash are us today, who don't learn, I think, that all-important lesson from the generation of the founders, which is to look at the lessons of experience, do what Mr. Jefferson, I'm not sure that I believe in a revolution every 19 years, but he did believe in conventions and actually scrutinizing the extent to which the Constitution's working well, and it's not.
So this is a lot of fun. I appreciate Sandy's comments about Lincoln. And so I thought, when I wrote this last book of mine, which is not on sale today, unfortunately, which is about what makes for great and bad presidents. And we do tend to focus on the great ones, particularly Lincoln, FDR, and Washington. And what I wanted to do was restore some attention to the loser presidents, right, the bad ones. And so actually, if you were to look at, and the Federal Society helpfully did a poll of 300 scholars. They do it every few years, asking us to rank presidents. And the outcome of the list from 1 to 5 is remarkably unchanged over the years. There's not a lot of fluctuation based on political party or what field of law you study. There seems to be a fair amount of agreement about who is a great president, who are bad ones. And the interesting thing is if you look at the ones who are at the bottom, they actually do tend to have a high level of very accomplished people. So the worst president by unanimous acclamation is Buchanan. And so, when I mention this at college audiences, some of the students start thinking Buchanan, because they think Pat Buchanan might have been president when they were kids. But I am referring, in fact, to James Buchanan, who was the president right before Lincoln. Well, an extremely accomplished guy. Senator, Secretary of State Senator from Pennsylvania, Secretary of State. He'd done everything you were supposed to do and be a good president. And he thought president had no right to stop secession, to head off the Civil War. Another person I would actually put down in the bad presidents area, and there's more disagreement about this, is Madison himself. So I think Madison, if you look at his presidency, he was probably one of the smartest people to ever be president. But he actually did believe in executive deference to the legislature, and is particularly in foreign policy, and he let the country be run into the War of 1812, which actually is probably the worst war we've ever been involved with from a strategic decision-making perspective. This is a war where the United States is neutral between England and France. We make a lot of money trading between the two, which we always do during wartime. And we decided to declare war against the only country that has a navy and troops on our border. Right? And why? Because we want to invade Canada, which is an obsession. I'm originally an immigrant. I don't understand the obsession with taking over Canada. All the smart Canadians move here anyway. Although
it's for the donuts, John.
We would have had universal health care a little bit faster, though, I suppose. And it was a disaster, right? Our effort to invade Canada were repulsed. The British took our capital, burnt it to the ground. And this is what happens when you have congressionally led, I think, action in the area where the framers did think you should have a vigorous executive, not a deferential executive. Secondly, for Tino, I thought that Tino had a very interesting point about how exercises of executive power are really a response to Congress putting more and more responsibility, more and more duties, passing broader and broader legislation. Although I wonder whether there's a difference between presidents like Reagan and maybe a president like Clinton or so on. That all those cases I think you mentioned are cases where the Reagan administration was trying to deregulate. They were in fact trying to use executive power to try to pull back the expansion of federal regulation of the economy and society, as opposed to maybe a different kind of president who might use their regulatory power to try to expand beyond or expand as fully as Congress would like. And so I wonder whether we can distinguish between those two kinds of presidential power in regard to reaction to Congress. The second, I think you're quite right. I think it's quite right that all presidents have responded to this phenomenon by doing some of the things mentioned on the last panel, like trying to centralize authority, trying to put cost-benefit analysis agency-wide. And I think it is I think the Czars in that respect are just a response, again, to the presidency becoming excessively, I think, involved with the execution of legislative policy, involved with the administrative state. It's just an effort to try to control it. So I can totally understand it. I think it's done in the wrong way, but I can understand why presidents do it. The last one I had with John Harrison, I thought that was interesting. I really admire his effort. As Judge Griffith was saying, every Federal Society convention has a panel on presidential power, and also every Federal Society conference has someone who traces all the world's ills to Morrison versus Olson, right? And all to the loss of control over the removal power. And I think there's something to it. On the other hand, I wonder whether even if Morrison versus Olson had never happened, and even if we lived in the Myers versus United States world where presidents could freely remove any member of the executive branch, would it really cure the problems we've had with the administrative state? Would it really enable a president to really centralize control over this enormous administrative state that we have now that's involved in every area of human life? In fact, sometimes I worry that it would be such a distraction, such a demand on the time and energy of presidents that they would spend so much time on this and they would lose focus on important things, I think, which is like foreign affairs and national security. So the last example I'll just throw out there is FDR. FDR actually signed all these bills creating all these limits. FDR was, very much in favor of a vigorous executive, but he accepted these limits when it came to domestic policy. And to play Sandy's game of, how do presidents do when they're in office, I would bet if World War II had not happened that FDR would have been considered a mediocre president, because I don't think now people believe the New Deal really did cure the Great Depression. I think it was really when he focused on foreign affairs and the coming of World War II and did violate congressional statutes to try to get us involved in the conflict earlier than Congress wanted. That's when we began to consider him a great president.
This is great stuff. I'm just going to be brief because I want us to get to the questions, but I want to just note that this gives me a lot of great material to talk to my kids about. I'm still a little crazy here. So the main point I want to make is I'm intrigued by the interest in rethinking what a constitution looks like, should look like, but I would just urge us to approach that task with much caution. There is a lot we don't know about how bureaucracies, how governments and how people respond to changes in structure. And even when we do know something, I think it's important to recognize that in part the institutions we have are probably to some degree adapted to who we are as a people, to our structure, and to our history. So getting inferences or ideas from how things work in other countries, I think, should just be done with a lot of caution. And the second point I wanted to make is there's always a question of whether when you observe the behavior of the executive branch, you're observing something that is a consequence of a particular structure or a set of legal decisions, or whether you're in fact observing a reaction to our larger social context, our technological context. And I do think it's important in a discussion like this one to highlight how much the nature of the presidency has changed as the technology that allows presidents to connect with the public has evolved. Think about how Roosevelt used his fireside chats. Think about the impact of television on the 1960 presidential debates. Think about the impact of social media on the 2008 presidential election. So as we think again about this whole question of redesigning or reshaping or rethinking what we expect from the presidency, we should know that some of what drives that behavior really isn't located in the presidency itself.
Since we're doing Get Beyond the N=1 in talking about presidents and discussing some of the underappreciated presidents, I do want to say something, and this picks up with something that a number of us have been talking about. Either the first or second most important constitutional designer who also served as President of the United States, and maybe Madison is first and maybe he is not, But if Madison is first, the second is Martin Van Buren. Van Buren created the modern political party. And he created the modern political party for two reasons. One, he didn't like the way the Constitution worked. And two, it was too hard to amend the Constitution itself. And so because he thought there was an overwhelming tendency for power to be centralized in Washington and for the elites who were in charge of the government, and in particular the executive and the courts, to get out of control of the people, he designed an entirely new and an entirely extra-constitutional means of controlling the government. He created the Democratic Party, which was supposed to be a way of keeping the bad things that he thought had begun to happen under the Constitution from happening. It has had a lot of, the creation of the political party has had some anticipated consequences, some unanticipated consequences, but it has had overwhelmingly powerful consequences for the country. And once again, one of the problems with having a constitution that is so hard to amend is extra-constitutional means or para-constitutional means like systematic Supreme Court appointments will be used to accomplish something that amounts to a constitutional amendment. And if you look at Van Buren's original design for the way a political party was supposed to work, it was a little disturbingly Leninist. Its purpose was permanently to exclude from the political process the people he thought were especially dangerous, the rent seekers who would seize control of the national government. And he gave the blueprint for the party that controls the government outside the Constitution. And again, it has pluses and minuses. But the temptation to do that sort of thing when you have a Constitution that is as hard to change as ours is going to be overwhelming.
Great. Thank you. I think we're at a point now where we can open the discussion to members of the audience. So if you would please come to the microphone and identify yourself and direct your question at a member of the panel, and we'll reserve time for Professor Epstein to ask a question.
Dean McGee, I'm chapter president at St. John's University Law School. I want to put James Madison back in the spotlight in terms of foreign affairs, and I'd like the panel to respond to what Madison wrote about the power of the president in the Constitution. And he wrote, "In no part of the Constitution is more wisdom to be found than in the clause which confides the question of war or peace to the legislature." And he goes on to explain why one man should not have so much power to take an entire country into war. And I was wondering if any members of the panel disagree with Madison as a question of constitutional interpretation, and then further, if any of the members of the panel disagree with him as a matter of whether that is a wise clause of the Constitution.
Everybody's looking at me. I don't know why. I think it's a great question. I assume you're reading from Madison's participation in the Helvetia Pacificus debates, which of course take place after the ratification of the Constitution. And this is something people debate about, whether historians, Jack Rakov here at Stanford has written a very interesting essay about whether Madison is consistent between when he was acting as one of the framers in Philadelphia and the ratification, and then once he became basically one of the leaders of the opposition to the Washington administration, which is the context within which he was writing. I think, his comment doesn't really address the issue we have today, which is where you have a large military that Congress has created and voted for and maintains from year to year at the president's control. And the president, I think, effectively has the decision whether to employ it in hostilities or not. I think Madison's right when it comes to the idea of declaring war and putting the country on a sort of mobilization or war footing. But what I don't think Madison's comment addresses as a matter of the original understanding is how Congress was supposed to control the executive once it already has created this large military. In the time Madison was writing, there was no standing military, right? So if any president wanted to have a war, they'd have to go to Congress and ask them to build the Army and Navy for that war. And the thing that changed significantly, this actually does go to Sandy's point also about constitutional design, things have changed. Maybe one of the biggest constitutional changes is that we now have the standing military that the framers were worried about. And Congress, I think, has plenty of tools to stop the president from using it if it wanted to. I think what Congress prefers is for the executive branch to make these decisions about war and peace and gives that president the military to do it, and doesn't want to take any accountability or responsibility for successes or failures. And I think that's really what happened in Libya. As a matter of constitutional design, I actually think that the system makes more sense to me if Congress creates the military, gives the president a fair amount of discretion on how to use it, and then Congress has the control through via the purse and the control of the size and shape of the military. I think that I would worry about a system. Some people read the quote that you've read from Madison. I would worry about a system that was biased, extremely biased in favor of inaction. I think people say, well, Congress is a less warlike branch and the president is the more warlike branch, so we want to create as many checks as possible. This was John Hart Ely, Professor John Hart Ely's theory of war powers. But I think one mistake with that is that it fails to recognize that not acting can harm the country too. We commonly think of wars that are bad for the country. The country can also be harmed by not going to war when it should. And I think the best example of that is the years leading to World War II, when Congress actually used its powers to really try to prevent the United States from assisting the Allies. And I think, to his credit, I think FDR tried his best to try to get around the laws to help Britain and France against Nazi Germany.
Thanks. This is my opportunity to use what I had originally prepared to say and then changed at the last minute, which is, but first, it's important in thinking about the relationship between the executive power and the legislative power to bear in mind that although we tend to think of them as antagonistic, they are in fact complementary to one another. And what the executive does is carry out decisions generally made by the legislature. And in turn, the legislature creates the legal environment within which the executive exercises its powers. And specifically with respect to war powers, I would go farther than John Yoo in describing the kinds of controls Congress could exercise with standing laws if it wants to. It seems to me that it's not just the size and shape of the military, but Congress could adopt, because it has the power to set up the armed forces, Congress could adopt a mission statement for the armed forces. Congress could enforce that through the power to declare war by saying what the circumstances are under which the United States will be at war and which it will not be at war. And when it's not, the legal privileges of war are not available. It can enforce those points furthermore by creating war crimes with its authority to make rules for the government of the land and naval forces. So Congress has very extensive authority not to micromanage, but to legislate in considerable detail with respect to how the military is used. As a general matter, Congress has not done so, and one of Congress's weaknesses has been the failure to do so and to retreat to the position that's associated with John Hart Ely and that you see in the War Powers Resolution, which attempts to create a default against military action and saying, oh, only if we affirmatively say it is it authorized. I think that's not an accurate description of congressional power, but the result of Congress's approach is they tend not to use the powers that they, I think, pretty clearly have.
Yeah, again, I basically agree with what John has just said. I think if one were trying to envision drafting a 21st century Constitution, one might, for example, accept the proposition that the president should be elected for a single 6-year term, among other things, so that the president doesn't begin running for re-election the day after the previous election day. Generally, I've been adverse to that, but I find myself more than willing to accept that as a possible approach if it is combined with the ability to fire a president in whom one has lost confidence through a vote of no confidence. That it does seem to me that one of the very bad features of the United States Constitution is the rigidly fixed term presidency, because if we do have a president whom we view as incompetent or just prone to bad judgment, which I think incidentally is worse than being a crook or worse than running afoul of some lawyer's reading of what a high crime misdemeanor is, then I wish we had a way to get rid of a president. I'm not sure that the California system of recalling a governor is exactly the best way to do it, but again, I come back to my theme that we have 51 constitutions in this country. and they do provide a variety of solutions to the problem of political leadership in whom one has lost confidence.
Next question, yes.
Hi, my name is Luke Ragland from University of Colorado. Professor Yu, I enjoyed your remarks, but there was one point that I kind of am getting stuck on, and I just wanted to get your opinion. You sketched out the founder's vision for a president whose role in domestic policy was very limited. Assuming that that's true, aren't the stakes too high? Aren't the stakes too high for domestic policy? The structural setup that we have for the presidency, isn't it inevitable that you're going to get a president who's very active in domestic politics? So does that matter that the founders had that vision?
I think that's a great point, because we have a political system now where we hold the president accountable for everything, and we demand that the president solve unemployment, or we demand that the president have the answer to the budget problem, even though those are things really which lie within the hands of Congress. So presidents have, I take your point, I think you're quite, presidents have responded by trying to place more control over passage of legislation and over administration. And I've always wondered, what if you had a president who came into office and started saying all that stuff is Congress's fault, and I am not responsible for what Congress has done in health care. I'm not responsible for A, B, and C, and D. It's their fault. And then used this is sort of trying to get at with my comments on Tino's presentation, was what if the president, I think this is kind of like what Reagan did, what if the president said, all the discretion I actually have, I'm going to try to use actually to cut back on all the things Congress keeps trying to get me to do, and actually uses it in a deregulatory fashion or a more limited government fashion. Reagan was extremely popular for doing that. I mean, I think Judge McConnell was quite right when he described today's administrative state as being so complex, prone to corruption, makes no sense to regular people. So maybe there's a space for a president to do something politically that is actually consistent with the original constitutional vision as a president campaigning, saying, I'm campaigning on the domestic political platform of less, right?
Thank you.
And used his powers that way.
Can I just add a quick comment to that? I appreciate the question, and I agree with the thrust of your question. I would just note, to echo something that John said, my view is that the prominent legislative role of a president in the domestic sphere happened relatively early after our constitutional framework was moved into place. I would note also that at least since Teddy Roosevelt, I've seen historical support for a fairly prominent presidential role in administering government. It varies from presidential administration to presidential administration. The focus changes, but the extent of the president's ambition to play a coordinating role is there. And with respect to John's interesting point about deregulation versus expansion and regulation, I'd just make two observations. The first is that there is a black letter law answer to whether there's a distinction there or not, and the answer is basically no. That's the State Farm case. Now, one could disagree with that, but that, I think, is an important piece of the discussion. And second, the pattern of presidents being concerned about the national level implications of regulatory action is not a pattern confined just to presidents of one party. I think it's very striking, and in fact something that folks have treated as an important moment in the development of the presidency, that following Reagan and following George H.W. Bush, President Clinton essentially kept the framework in place that allowed for review by OMB of regulations, and certainly that has continued to this day.
I just want to make one more comment about this point, because John and Tino have mentioned it, and I actually looked something up before I came, a quote, so I wanted to use it. Just like a law student in class. So this question of what happens when Jefferson becomes president and his heavy cooperation with the legislature. So John Marshall, who personally did not get along with Jefferson, was asked what did he think Jefferson was going to be like as president. And so he wrote a letter where he said he thought Jefferson was going to be somewhat dangerous as president. And they said, why? And he said, because Jefferson is going to, quote unquote, embody himself in the House of Representatives, which would increase his personal power. But Marshall also thought it would lead to a weakening of the office of the president to do that. And the reason why, I think, actually came to fruition in the years after Jefferson, which was that if the president so closely cooperates with the House and the Senate and uses a political party system to do that, we might start to approach a system where the Congress chooses the president. In the years after Jefferson, basically the Republican Democratic Party created a caucus in the Congress, and they would pick the presidential candidates for the party. And you had the situation which the framers really didn't want, which was congressional selection of the head of the executive branch.
I realize we're in the area of constitutional design, so there's some sense of not being tethered to historical precedent here. But I just want to ask you, Professor Yu, a follow-up question on the question that was asked. You're suggesting that it might be politically palatable for a president to say, "I will do less." Is there any example? That seems to me to run counter to sort of anthropological thrusts here. That in fact
that sounds like something dirty.
No, it's not intended to be. So isn't there a strong imperative to want a king, and in fact that what we see in the Constitution is an accession to that in part, but limitations on it? I'm just wondering if that's. Yeah. I know this is all in the area of design, and perhaps none of it's realistic, but isn't that perhaps the least realistic thing that we've heard today, that a president who would say, "I'll do less," would be successful?
Well, first, I think I've said a lot of unrealistic things, so it's unfair to pick this one thing out. But I think I think there's some scholars who are on this train to rehabilitate Calvin Coolidge, right? Maybe Calvin Coolidge. Maybe Calvin Coolidge is an example. He comes in right after World War I. Wilson builds a huge bureaucrocy, which later becomes a model for the New Deal state. But Coolidge, in office, tries to actually do a lot to cut back on the size of the federal government. People tend to, or their books, people writing books and articles, I don't know what I feel about Coolidge being actually a very successful president in this regard. But it raises this bigger question, which is, I think, so Sandy mentioned there are certain contradictions in the office. And one of the big contradictions is head of state versus being a prime minister. And we expect the president to be both. So I guess what I'm doing is making a pitch for the president not to be prime minister and to be more the head of state. I think Sandy, just from what I can take, you didn't say this, would want the president maybe more the prime minister and less the head of state, that you would want more coordination between the president and the leadership of Congress, and hiring specialists, like in England, specialists to the cabinet but I'm not convinced that that's actually the way to go. I look at what's going on in Europe these days as a good example of the European parliamentary model not necessarily being superior to ours, which a lot of people in political science used to assume was true.
Part of what I mean by head of state is bands that play Hail to the Chief, and where you see the great leader's picture on every post office and every federal office. And I think that ultimately is pernicious, precisely because it becomes very difficult. I mean, I'll quote a great Texan, H. Ross Perot, who, when he was running for the presidency, he said, "The president is an employee, and if we don't like our employee, we should be able to fire him." Whereas if you have the bands and the photographs, the extraordinary Secret Service details, the cult of the presidency, it gets much, much harder to view the president as an employee, and it becomes, in a civil religion sense, sacrilegious to say that this is somebody we would be well rid of because he, or in the future she, just isn't up to the job, and it would be dangerous to wait to the next election. So in that sense, I would like a somewhat more parliamentary system, but I don't know that you have to go all the way to a parliamentary system. That's one of the reasons I want a constitutional convention, in order to have systematic discussions about what a constitution of the 21st century should look like.
Quickly, I'm totally with Sandy on having a constitutional convention.
See, I'm not the most unrealistic person on the panel.
I didn't say it was going to happen. I mean, come on. Here's something else that's not so likely to happen. Well, it may or may not be possible for a president just to say less, but a political party can, and political parties from time to time do so. But if you're going to say that that function can perhaps more readily be performed by a political party, which doesn't have the imperial overtones that come with the presidency, then to some extent you're going to have a presidency that is going to be more prime ministerial.
Yes, next question.
Good afternoon. I'm Kevin Douglas. I'm a second-year student here at Stanford Law School. I have a question for, I guess, clarification based on something Professor Levinson said. And it was basically the comment that the Constitution doesn't work. I would think that judging an institution as working or not would depend on what the purpose of that institution is. And I'm curious as to when you said that, did you mean the purpose of the authors of the Constitution, a more modern purpose, or a more modern purpose? And if it was the first, I think, what purpose did the authors intend that you think we're failing to achieve? And if it's the second, why would it be valid to consider a modern purpose as in calling the Constitution itself a failure or not working? Why would it be valid to consider a modern purpose? Thank you.
Wonderful, wonderful question. I encourage you to see 400 pages of trying to answer it. Very quickly, one can say that one purpose of the original Constitution was to create a little r Republican political order that would be as insulated from the democracy as possible. And rightly or wrongly, that has not really sustained itself as a working definition of American political ideology. Again, with regard to originalism, there's a chapter in the book on the preamble, which I think is an unequivocally wonderful part of the Constitution. And I think one way you assess any Constitution, whether it's the national Constitution, the Constitution of Virginia, whatever, is to try to get a sense of what are its purposes. That's a function that preambles play. And then you just ask, well, to what extent has the Constitution allowed us to achieve those purposes? And I would argue not very well. Shifting to another realm entirely, I think it is relevant that right now Congress has an approval rating of 11% or so. That I'm not sure where the president is today right now, but I think it's well under 50 in terms of an overall approval rating. That I don't think you find great support for basic American political institutions. It's the military. The military is the one and only American political institution that has a confidence level of 94%. Even the courts are, I think, most generously looking at the data, are only somewhere in their 60s. And if you ask specific questions certain ways, even the Supreme Court say it would be under 50%. I think that ordinary people, evaluate government on the basis of output. And I think whether you're left, right, and center, unless you really love the status quo, you're not going to find the contemporary American national government very satisfying. So that's another way of evaluating. It's the shoe, this is the shoe pinch theory. It's not an originalist theory. But one thing government is supposed to do is to create a relative sense of content among the populace, including the feeling that if you win elections, you can really do things. But one of the things that our extraordinarily complicated national system ensures is that elections, at the end of the day, mean much less than one might think. And that's something we should talk about in the 21st century.
Thank you. Next question.
Colin Glassy, I'm a 2L at Santa Clara. My question is directed largely to Professor Harrison, but anyone can answer. I would argue that the totality of circumstances surrounding the Libyan operation have effectively ended the War Powers Act as a functional or in any way meaningful break on presidential behavior vis-a-vis foreign countries in essentially warlike conditions.
There is certainly something to that, but I do think that part of what is going on with the weakness of the War Powers Resolution is that it was an attempt by Congress to constitutionalize an issue that is primarily governed by statutes and that hence Congress could control directly. The first operative part of the War Powers Resolution is simply a declaration about what the constitutional rules are. And if you think that Congress is wrong about those constitutional rules, which I do, then it's just another view of the problem. And that, I think, actually then that undermines, I think, the effectiveness of the 60-day deadline. And although I'm not much impressed with the argument that there were no hostilities underway because although we were in a position to shoot at the Libyans, they in effect couldn't shoot back. It seems to me that just as an interpretive matter, it's a sufficient condition for United States forces to be in hostilities when it is permissible under the law of war for the other country to shoot at them, even if they don't have weapons that can reach them. But the problem with the War Powers Resolution is an attempt to build its enforcement mechanism into what I think is a flawed view of the constitutional rules. And if Congress had proceeded differently, not by saying this is our attempt to build out the Constitution and to replace a vague notion that the president can act only for a while provisionally, we're going to make it 60 days. If they had legislated in a different format, I think it might have been substantially more effective, but they got into we're constitutionalizing this mode, and I think paid a price.
I think this is also an area where John is absolutely right about the importance of Martin Van Buren, that the idea that it's Congress against the executive or the like just avoids what Rick Pildes and Darrell no relation Levenson have pointed out, is that the party system is really more important than the structures, that a Republican Congress was happy to give George W. Bush authority that was actually based on the UN resolution. I think that if we're going to talk about checking and balancing, then I'm not sure how one does it, but to rely on Congress vigorously to assert its own prerogatives against a president of their party, so to speak, clearly doesn't work. The War Powers Resolution is based on a Madisonian notion of the national government that hasn't been descriptively accurate since 1800.
I was going to say, I don't think even people in Congress want to fix the War Powers Resolution problem. It was a convenient symbol that Congress was doing something about war powers as a way to avoid doing the things I think we all agree Congress could do. I mean, you could just cut off funds or not pay for any of these conflicts. Libya, I think, might have been so small that you might have been able to wage the whole thing without, by reprogramming money in the Defense Department, but Kosovo wasn't. You had to vote an appropriation for Kosovo right away. So it's one thing is that. The other thing is about the political party thing. In Kosovo is interesting because in Kosovo, President Clinton went to war. It went beyond the 60-day clock. Courts wouldn't adjudicate it, but Congress was controlled by the other party at that time. And if you remember, it was funny, one of the 10 things in the contract with America that Newt Gingrich wanted to do was repeal the War Powers Resolutions. You had a case where a Congress of the different party actually wanted to add to presidential power and war powers and repeal the War Powers Resolution, which is hard to figure out as a political matter. Newt didn't succeed on this one, so he's not bragging about it now, I suppose. The last thing I'll say is that I think that Congress could easily achieve the War Powers Resolution result just through the funding power, I think. So if John was saying, well, all the president needs is the removal power to maybe run the executive branch, I think that Congress can get most of its way through the funding power. The way to really get the executive branch to do what you want is just to start placing riders on appropriation bills, start threatening to cut things off from the budget process, and it could easily stop, I think, any war that the executive branch would want to get into.
Thank you. Yes, next question.
Yeah, Raimi Hernandez from the UNLV chapter president, UNLV School of Law. Professor Levinson, you talk about the counter-majoritarian difficulty, but I can't think of anything more antithetical to counter-majoritarianism or that idea of the difficulty of it than having a referendum on the president, because that will just be swayed by whatever the majority wants at the time, or by not having a two-thirds majority veto, because that could just be swayed by whatever the Congress at the time. I think of the Chinese Exclusion Act vetoed by Grover Cleveland as an example of a president exercising his, counter-majoritarian influence. And, having lived in California for many years, I can tell you that the recall wasn't we got rid of Gray Davis, but, the replacement was not necessarily the most successful governor. So I'm just a little bit perturbed by these suggestions, and I think that they could actually work against that counter-majoritarian problem.
I mean, what you speak very much is the view, I think, that was dominant in the Philadelphia Convention, because it was anti-democratic with a little d. And, I think the most pervasive theme of the Federalist is a mistrust of actual government by the governed. The The Philadelphians were trying to create a government by a virtuous elite, and there's much to be said for that as a normative political theory, but it clearly didn't stick. I also think, and here I betray the fact that along with being a lawyer and political scientist, I think it's very important to talk about frequency distributions and not focus on undoubted examples of ends of one, which are either very commendable or very awful. And to decide, to try to get some sense of the lessons of experience overall. I mean, a lot of states have direct democracy. There are some horrible examples of direct democracy. They may exist more frequently than in other states in California, but if you look at the origins of direct democracy in California in the early 20th century, it's because of a basically accurate perception that the California legislature was bought and owned by Leland Stanford and his friends, and that it was viewed as a very important safety valve for popular government. You can say we have learned over the last 100 years that there are also problems with the safety valve, and we could negotiate about whether it should be straight up and down majority votes. I mean, you look at the elected judges, which is a very exceptional aspect of American exceptionalism. The barn burners in the 1846 New York legislature rationally supported the move to an elected judiciary because they recognized, again, altogether accurately, that the judges were friends of the governor, whose job was to uphold basically whatever the governor and his legislative allies wanted to do. You can say elected judiciaries have their problems, but God knows so do appointed judiciaries. And all I want, and I'm delighted that John endorses this, is a long overdue national conversation about these structural details based on looking at the lessons of experience to try to figure out what might make sense. One last point with Tino, who criticized how things work in other countries. One of the reasons I so much now want to emphasize the other 50 constitutions is that, on occasion it might be useful to look at Germany or South Africa or even France, but I'm happy to, accept a blinkered notion that we look only within the United States and we still find a lot of really interesting variation that could allow us to have a meaningful discussion in the 21st century.
Your point is well taken. I appreciate that, but I do want to say it really hurts what you said about Leland Stanford.
One last question here. Yes.
I'm Lexi Schechtel, a 2L at Stanford, and given that this is the Federalist Society, my question is that given that the Congress really hasn't done anything to resist executive power, what can a state or a group of states do to prevent executive branch inroads into state activities?
I think that's a really interesting question. The one point that I would make about the premise of the question is I actually think that Congress has done a good deal to resist executive power. The best example that we can talk about for a while is Watergate and what happened immediately after Watergate. I think you could teach a whole class about the 7 or 10 statutes that Congress passed immediately following Watergate. Now, but what strengthens the premise of your question is that, of course, that's not the typical thing we see from Congress. But even today, I think, for example, with respect to budgeting, we are living under a statutory scheme that does reflect a congressional reaction to executive power.
Yeah, I also, probably John is most famous or infamous, depending on who the speakers are, with regard to writing about a lot of attempts by Congress in the previous administration to resist what was regarded as overreaching by the executive, and that brought forth the spate of signing memos that we could certainly have argued about, I think unproductively, for the last hour and a half. But it does seem to me that it's not so bleak. If we had more time, we could talk about secession as the ultimate mode of resistance. My governor has flirted with that idea.
Okay, we now have the winner for the most unrealistic comment. Thank you. Thank you very much. Now,
Speaking of things that were tried and didn't work.
That's right. Before we congratulate our panelists, I've been asked to read a very important announcement from the organizers. I've been asked to inform you about a panel that is not in the printed schedule but may be of interest. During the next period, 12:45 to 2 p.m., during the lunch period, the Federalist Society's faculty division will host a panel on preparing to become a law professor. The panel will take place in Zambrano, am I pronouncing that right? Zambrano Hall, room 301. That is the room directly above the CMEX auditorium, and it can be reached by taking the outside stairwell or the elevator to the third floor of this building. Panelists will include Professors Barnett, McConnell, and Volokh, and Lee Lieberman Otis, the director of the faculty division. Law students and graduates who are considering an academic career are welcome to attend. Feel free to bring your lunch from the CMEX lawn up to room Z301. The panel will start no later than 1 o'clock and will conclude in time for the Affordable Care Act debate. Now, if you'll join me in thanking the panelists for a lively discussion.